this morning. So we are continuing our discussion of natural law school, which we started the last time. And we did make the point that the natural law school is that school of thought in jurisprudence, which espouses the point that it is not enough for us to know what the law is. It is equally important for us to know the merit of the law. In other words, is the law delivering justice? Is the law in accord with our conscience? So the normative quality, the normativity dimension of the law is as important as the law coming from the authentic or the former or the legitimate source. And we said that that is what draws the line between legal positivism and natural law. And that kind of distinction finds expressions in what we call the is-ought dichotomy, or the is-ought thesis. The thesis refers to the legal positivism, and then the ought thesis refers to the natural law. So as we indicated for the is, of course, we'll come and discuss legal positivism extensively. The is, they hold the view that is the law coming from the legitimate source, the appropriate source from which the law is supposed to come from. If the answer is yes, then the jurist has finished his work essentially, and as to whether the law has a certain moral quality or not is a separate matter from the law coming from the appropriate source. So there's a probability thesis. That's another way of putting it. But then the natural law, as you realize, is not interested in just the law coming from the appropriate source, but more importantly, as the law satisfy a certain moral quality. So we look at how natural law thought has evolved over the ages, and we went back to the ancient Greek time to look at the Roman era, and we came into even the Christian era, and we discussed St. Thomas Aquinas' views, and we also discussed, for St. Thomas Aquinas, as you remember, he came to integrate reason and nature. Some natural scholars for a long time had seen looking at natural law from the point of view of reason as being irreconcilable with looking at natural law from the point of view of nature or from God. Now, Aquinas came and said that, well, the two are not mutually exclusive. And you can have like a very harmonious relationship between the two perspectives. And that is why he evolved the four kinds or typology of law: the eternal law, that is God's law for governance of the created world; divine law, that is a God law as revealed in the revelation of scriptures; then the natural law, when rational creatures, that is human beings, uses their mental faculties in order to participate in the eternal law, then that is like the natural law. And he also acknowledged that it's not everything that we can expect all human beings at every point in time to use their reason to determine what appropriate precepts are. And it is necessary to still have a human law or positive law. So that is like the fourth kind. Now we also move on to discuss Hugo Grotius. And Hugo Grotius, as we told you, also came at the time when there had been an attempt to secularize knowledge, the Renaissance and Enlightenment era, a period. And Hugo Grotius will make the point that, yes, natural law can be understood even if a person did not want to believe in God. And he made like the famous statement, etiam daremus non esse deum, that is, natural law will subsist even if God did not exist. Just trying to tell us that if you look at how things are in the created world, they are intrinsically manifestation of the reality of natural law. And for that man, that is why he went to the extent of saying that even if, assuming I'm in touch with, just for sake of discussion, that God did not exist, natural law will still exist. That was the point Hugo Grotius was trying to make. Now we want to explore the contribution of social contrarians towards natural law thinking. There are some scholars who propounded the social contract theory. So what did they bring on the table as far as natural law thinking is concerned? Now, in this respect, we'll be exploring Thomas Hobbes, John Locke, J. Rousseau. So we'll look at them before we come to Rudolf Stammler, and then we'll look at the Fuller and finish, and we should be finishing natural law. So Thomas Hobbes, who made his contribution around the 17th century, based his thinking on natural law on the premise that man's basic instinct was that of self-preservation. And as we often say, that the first law of nature is what? Is self-preservation. Self-preservation simply means that, I explained it the other day, that every human being would like to keep himself safe from danger, from destruction, from death, as it were. And that explains why when you are sick, you want to take medicine, isn't it? Why will you go to hospital? Because you don't want to die. Why will you eat food? Because you don't want hunger to kill you, isn't it? Why will you drink water? You don't want to get so much thirsty that you collapse and die. You want to preserve yourself. In much the same vein, if there is any danger in your environment, we would like to act instinctively so as to avoid harm's way. So therefore, Thomas Hobbes would argue that man had a natural right to self-preservation. And he imagined how society was before we came to have the modern society that we have. So the current society, he will try to understand it on basis of social contract, that the state that we have, the citizen and everything, we can understand the power of the state to demand obedience from citizens, the right of citizens to demand protection from the state with respect to crime, violence, and so on basis of existence of what they call social contract. But Hobbes makes the point that before this social contract was actually formed, man was in a state of nature. That is to say that we didn't have the kind of society that we have, the state and all that we have. And everyone was on his own. And in that state of nature, it was characterized by internecine warfare, where life was quite rough. And he'll use a famous cliche that life was nasty, brutish, and short, in the sense that it was like might is right. If you had something and I could beat you, I could overpower you, I just do that and get it. If you were a woman and I wanted to go in you, I just pounce on you and sort of literally rape you. Or if you're a woman and you wanted to have a man and you are strong, you just do that. Like, the point is, everything was quite rough. Everything was quite nasty, brutish, and because there was no order. There was no order. The only order was might is right, so to speak. So what that meant was that man was in a really state of misery, because you could die, you could get destroyed at any time, depending upon who you were dealing with. So therefore, to preserve life, social contract was formed so to speak. And what does this social contract? By this social contract, a man, instead of just being on his own and having untrammeled, absolute freedom, and then he or she could do whatever that he wants in order to have his way, and he too was also at the mercy of those stronger than him or her, surrendered his natural freedom to a sovereign to form an orderly society. And it's because of this that law and government become necessary. So for Hobbes, law is necessary, government is necessary because of this original contract, which we call like the social contract, in which for the sake of protection, for the sake of getting ourselves destroyed by one another, let us surrender our freedom to a sovereign, for the sovereign to put in place an ordered arrangement for everyone's protection. So every citizen becomes politically obligated to the sovereign. All must obey the sovereign as a prerequisite for justice. And Hobbes will make the point that there cannot be an unjust law emanating from the sovereign, and it is only the sovereign, it's only when the sovereign cannot guarantee the preservation of the citizen that the obligation to obey the law ceases. In other words, so long as the sovereign is providing protection, then the citizens are obligated to obey the law, to obey the sovereign. Should it happen that the sovereign is unable to deliver protection, then the citizens do not have obligation to obey the law, because the justification for obedience of the law is not there. Yes, we have surrendered our freedom to you for you to make arrangements, law, and all that, so that we are protected from harm and disorder. And if you are not able to do that, then we don't have to obey you. So Hobbes characterized peace, which man desired, as a consequence of the need for self-preservation as the first law of nature. That yes, as we've indicated, man does not want to be embroiled in violence or disorder. And for that matter, man would like to preserve himself. And if that is so, you surrender your freedom to the state, and then the state is supposed to put in place the necessary arrangement for your protection. So Hobbes will say that the mutual divesting of individual right to the sovereign is the second law of nature. So first law of nature, self-preservation, okay? Second law of nature, that you give your individual right to the sovereign. And then the third law is the need to respect contracts voluntarily entered into. So you might have heard pacta sunt servanda from your law of contract in the first year. Contracts are sacred. There's a sanctity of contract, and the contract is supposed to be obeyed and all that. So all these emanate from the foundational dimension of social contract theory, so to speak. Again, when all these things are put together, that is the first precept, self-preservation, the second precept, the fact that you've given your individual right to the sovereign, and the third law, the need to respect the contract voluntarily entered into. When they are put together, they constitute morality, which is arrived at through the social contract. So in a nutshell, that is what Thomas Hobbes is telling us with respect to his understanding of the social contract. And how it fits into the natural law paradigm of thinking, which we'll be exploring, is this, that law, and for no matter government or state, is based upon social contract. And if the law made by the state, for example, is not protecting the citizen, the law is not, for example, facilitating enforcement of contracts or agreements and all that, then the citizens do not have any moral obligation to obey the law. So it's not just enough for law to have been made, but the law should be consistent with the original thinking behind the social contract. So that is what Hobbes will tell us. Another social contractarian is John Locke. John Locke also focused on the concept of natural rights. What rights and duties men have as creatures of God in a state of nature. That, yes, before we came to have like the modern state and all that, in a state of nature, human beings have certain rights. So unlike Thomas Hobbes, John Locke premised his argument with respect to social contract on the ownership of property acquired by mixing labor with the free gift of earth, which God has given to all. So to Locke, this was the prime value of morality. In other words, it was his view that if you look at human beings in a state of nature that is before we came to have like the modern state, that everyone had the opportunity, everyone has the ability, as it were, to apply himself or herself and appropriate part of nature, including the resources in nature, to himself or herself. So once you have mixed your labor, right, you have mixed your sweat with some of the things in the nature, they become your own. You acquire property in them. That is the point that he's trying to make, that ownership of property is acquired by mixing labor with the free gift of earth, which God has given to all. And for him, this was the prime value of morality. Yes, you can even relate it back to our own traditional society, especially if you remember your customary land law, when it comes to, let's say, usufructuary interest, isn't it? Yes, the family who having the allodia title, if you're a member of that family, you can cultivate any portion of the land, and wherever your machete or cutlass will enable you to cultivate up to. In a sense, you acquire a special ownership interest over that portion of the family or school land in which the allodia is held, and you acquire what they call a usufructuary interest, so to speak. I mean, that is the same point Locke is trying to make, that, yes, in the state of nature, God has created the world. All of us are there. It doesn't belong to anyone. However, if you apply yourself in terms of your sweat, your labor, to cultivate or to appropriate a portion of it, then you acquire ownership in that. So to John Locke, the state of nature was one of pure bliss. In other words, it was one of happiness, but there was one major inadequacy, one major shortcoming, and that shortcoming was that property was not secure. That is to say that when you have stressed yourself to apply yourself, your labor, your sweat, and you have gained something, you could not be too sure as whether you continue to enjoy that which you have acquired. And it was necessary for arrangement to be made so that the property that you have acquired will be safeguarded. So to remedy this situation, man gave up his freedom to a sovereign, so that the sovereign will put in place arrangement which protects your property. So law and government in Locke's thinking exists to secure the natural rights of the individual. So the natural rights of the individual is to have ownership in property. So foremost among the natural right is the right to hold other men responsible for breaches of the natural right of others. So if your right to property or your right to some freedom and so on are infringed upon, you're entitled to get it remedied, to demand accountability from the violators or the offenders. So, according to John Locke, the citizen must obey both law and government, so long as it is capable of preserving its natural rights by holding others responsible for such breaches. So the state has that responsibility to ensure that people who violate others' natural rights, such as people's property, like that is why we have the offense of stealing, right? We have the offenses like dishonestly receiving, forgery, fraud, and all the property offenses. They are there to check people who may want to violate others' natural right to acquire property, to speak. So let's keep that in mind. Oh, do you say the audio is off? Can you hear me? We have been talking for a long time.
Yes, please, we can hear you.
All right, thank you. Now we have, now let me say that because we need to cover a lot, we are just trying to outline the key ideas of these social contractarians. But as you go to the textbook, I would like you to read more about each of them. So we take another one, Jean-Jacques Rousseau. Now, let me also say that those of you who have seen my Ghana Legal System and Legal Method book, Volume 1 and Volume 2, I think if you take like the Volume 2, I have a chapter on the nature of law. So if you wanted a very quick understanding of most of these things that we are talking about, I think you can also read it from there, in addition to the standard textbook of MD Freeman Law Jurisprudence. Now, so what did J.J. Rousseau bring to the table as far as natural law thinking is concerned? Rousseau emphasized the concept of general will. So to Rousseau, the social contract was the way by which the individual merges into the life of the community and becomes part of the general will. And for that matter, law and government become the register of the general will and can only be tolerated so long as it accurately reflects the general will. So what Rousseau is simply trying to tell us is that our individual will, right? Our individual will merges into the collective will, what they call like the general will. And for that matter, the general will is characterized by popular sovereignty. And that determines what is good for society as a whole. So maybe if we liken it to Ghana, right, using J.J. Rousseau's thinking, if you go to the Constitution, reference will often be made to the public interest, right, or national interest. And then we also see in Article 1, Clause 1 of the Constitution that sovereignty resides in the people of Ghana, in whose interests and for whose welfare powers of government are supposed to be exercised in accordance with the Constitution. I think if you read Article 1, Clause 1 of the 1992 Constitution, we have a provision which reflect the substance as I have endeavored to recount. Now, I just give you another instance. Has anybody got the 1992 Constitution? Has anybody got it? If you have your Constitution, I would like someone to read is it Article 295? I think so. Can somebody open it for us? Article 295. I want the definition on what the Constitution means by public interest. Yes. Is somebody there?
Yes, my lord.
Yes, can you look up
Article
Article 295? Is that the interpretation section? What is the heading?
Interpretation, yes.
Yeah, good. So please look up what you call the public interest. I think the public interest is
Yes.
defined over there. Define it for us.
Yes.
Yeah.
Yes, found it. Public
Right.
interest.
or
Good.
advantage.
Okay, so public interest includes any right or advantage which inures or is intended to inure to the benefit generally of the whole of the people of Ghana.
Good. Good. So any right which is supposed to inure to the benefit of the whole of Ghana. Are you done?
Yes, that's all on the public interest. The next one is public office.
Okay, good. Now go to Article 1 Clause 1 and read that for us. Article 1 Clause 1.
Article 1, Clause 1. It says, the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in this constitution.
Good. And then read Article 20 for us on the doctrine of eminent domain. Composer acquisition, read Article 20. I think Clause 1, yeah.
Okay, Article 20, Clause 1 says no property of any description or interest in or right over any property shall be compulsorily taken possession of or acquired by the state unless the following conditions are satisfied.
Yes, go ahead.
A, the taking of possession or acquisition is necessary in the interest of defense, public safety, public order, public morality, public health, town and country planning, or the development or utilization of property in such a manner as to promote the public benefit. And B, the necessity for the acquisition is clearly stated and is such as to provide reasonable justification for causing any hardship that may result to any person who has an interest in or right over the property.
Move on. Are you done?
Yes, that's for article. Yes,
20.
that's for clause 1.
Okay. Then Clause 2.
Clause 2 says, compulsory acquisition of property by the state shall only be made under a law which makes provision for A, the prompt payment of fair and adequate compensation, and B, a right of access to the High Court by any person who has an interest in or right over the property, whether direct or on appeal from any other authority, for the determination of his interest or rights and the amount of compensation to which he is entitled.
3. Are you done?
Okay, so clause 3, where a compulsory acquisition or possession of land effected by the state in accordance with clause 1 of this article involves displacement of any inhabitant, the state shall resettle the displaced inhabitant on suitable. Clause 4. Nothing in this article shall be construed as affecting the operation of any general law so far as it provides for the taking of possession or acquisition of property.
Clause 5.
A. Clause 5. Any property compulsorily taken possession of or acquired in the public interest or for a public purpose shall be used only in the public interest or for the public purpose for which it was acquired.
Okay, good. Now, Rousseau is telling us that the social contract is based upon we individuals surrendering our individual will to merge into the general will, right? And the general will provides justification for what we call the popular sovereignty. And for that matter, those who represent our sovereignty, they are given the power to make determination as what is good for us as a society. And that is why in Ghana, for example, yes, Article 1+1 reminds us that the sovereignty of Ghana resides in all of us. However, all of us cannot be exercising the sovereign power at the same time. So from time to time, we elect government, right? We elect government, and then the government is supposed to exercise this general will, if you are using Rousseau's language. And that is why when it comes to matters which inures to the benefit of all of us as people, the government is given the power to determine it. So we have a sense of what the public interest or the public purpose is. And that is why we read the Article 295 and says that anything which inures to the benefit of the people of Ghana generally, or to some people, maybe to a section of the general people, that is the public interest. Now, the Constitution recognizes the right to own property or right. However, because the general will, because the popular sovereignty is superior to our individual will, should it become necessary that something is needed for the benefit of the general population, for society as a whole, or significant section of society, the individual rights will be sacrificed. And a typical illustration is what we saw in Article 20. But even there, you see a cautious interference with the right of the individual, that, yes, the right of the individual should be interfered with so long as it's absolutely necessary to safeguard the general will. It's necessary to safeguard the public interest, which will include also public morality, public safety, defense, and all that. So let us keep that in mind. So in J.J. Rousseau thinking, the general will replaces the higher law standard, which natural law represents. So more or less saying the same thing by using like a different word, different language. So leaving the original social contract theories, we would like to say a few things about another scholar called Rudolf Stammler. Stammler was a German jurist, and he was concerned with the formulation of the right law based on justice. And he propounded the idea of natural law with a variable content. And I want you to pay attention to this. Natural law with a variable content. Variable means that like the content can change. Now, all along, the salient characteristic of natural law we have witnessed is that natural law is universal. Universal means that it's everywhere the same. It's absolute, it's unchangeable, and all that. But Stammler comes to the scene and makes a point that we should be looking at a natural law who does not have a fixed content, and then the content can vary or can change. So he premised his thinking or his theory on the fact that each era, that is each period of time, has its own right law. And this should coexist with the positive law. And it is not the law of nature, but the nature of law, which was common to man everywhere. So pay attention to what he's saying. He's bringing a very radical, formulation or configuration of natural law, saying that yes, if you talk about natural law, properly understood, should not be that the law of nature, that is the law you can observe in nature, is universal. It applies to every human being everywhere. No. But in his view, the nature of law is that which is common to man everywhere. In other words, what is the utility of law? What is the function of law? What is the place of law in society? It is that which runs through everywhere. So in Stammler's view, if you look at, let's say that those who lived 100 years ago, or even Ghana, let's say that those who lived during the colonial period, the type of law that they needed will be different from what we need now. So for example, if we take, let's say that the nationalists, the intelligentsia elite, like our people who were educated and were trying to fight the imperialists or the colonialists, in those days, they'll be appealing to a certain type of, if you like, a natural law idea. The fact that it is immoral, it is unacceptable for someone from another country to come and impose himself on other group of people, take over their resources and all that. And so those are the kind of thing that it is not right to enslave people and so on and so forth. Now, in that period, maybe using the Stammler's reasoning, those matters were out because we had imperialism and all that. We had slavery and all that. But now, in 2024, the things that are needed, we have a problem of galamsey, we have a problem of various politicians, NDC, NPP, CPP has not come to power in a long time, making promises which they don't deliver, or they raise our hopes and they come to power and they will not do all and all that. We have a problem of, let's say, with corruption. We have a problem with, LGBTI. So these are, for example, issues confronting us now. And the aspect of natural law, which will be emphasized now, is different from that which will have been emphasized probably during 50, 100 years ago. I mean, that is a kind of reasoning Rudolf Stammler is trying to invite us to. So to Stammler, the content of natural law is variable in the sense that the standards by which positive law is judged varies with time, and it is dependent on the prevalent ethical and philosophical doctrine of the time. So philosophies or convictions or beliefs are not static. They evolve. They evolve. So for example, when it comes to, let's say that gender justice or women empowerment and things like that, if you go to our customary law, right? If you look at the case of Henry Kofi Antobam, I think it was I think Justice Redu as it then was the High Court judge like who decided it. Henry Kofi Antobam. The point will be made that if a man died intestate, that is without making a will, and left behind property, he left behind children and spouses. The children could continue to live in their father's property so long as they were of good behavior, meaning that the family of the deceased father could sack children from their father's own property. Because we used to have the matrilineal system of inheritance, and if you don't make a will, and that was it. Now, you look at it and you get a feeling that something is wrong, isn't it? During the mind's term, he might have used even assistance of the children and the spouse to acquire the property. But just because he did not make insamanso or he did not make a will, the children, the spouses are being denied entitlement as far as properties that they even help the man to acquire are concerned. So we look at, and then of course, women too were seen to be exploited. So in 1985, for example, we get the interstate succession law, which was passed, PNDC law 111, to impose a sort of like a uniform arrangement if a person died without making a will. I have a power challenge, so I think that I've just gotten indication that my power is going off. Unfortunately, I don't have what do you call like a extension to enable me to fit my laptop. I travel where I am, I don't have a good, I cannot get it. So when it goes off, let me see, then that will be the end of the class. Let me see how long can it go. Let me see. Saver on. Okay, I'll put the power saver on probably. Go a little bit. Yeah, so we got the PNDC law 111 passed and then imposed a uniform regime on everyone if you died without making a will, if you died intestate. So Stammler is just trying to make the point that yes, because our ethical and philosophical aspirations change over time, it will also have implications on what we consider to be the content of natural law in those times. And that is why he says that natural law should be seen as having a variable content which changes with time. So he will observe that the standards of natural law are not immutable. In other words, they are not unchangeable, they're actually changeable as society is in flux. Society is not static. Society is not static. And because society is not static and society keeps changing, then what it means is that our ideas of what we even consider to be right and wrong may also not remain the same, as it were. Now, we also have a very important contributor to natural law thinking, Professor Lon Fuller. Professor Lon Fuller is also the one who authored the hypothetical work, Spelutian Explorers. Spelutian Explorers, if you haven't read it, I'm going to let you read it about 2 times in the course of this course. He created like you say like hypothetical scenario. People will go, cave expedition. They got trapped and there's no food. They had to, cast a ballot to determine if one of them should be killed and eaten, so as to prevent all from perishing. Later on, they are rescued, and then they are arrested. They are charged with murder of the one they killed and ate, and they are found guilty. The law of the land says that they should be sentenced to death. Yeah, so it's a very interesting scenario. I would like you to read that. But let's come back to Fuller and then what he says with respect to natural law thinking. So Fuller was an American professor of jurisprudence at Harvard University, 1948 to 1972. He is a very important thinker as far as contemporary natural law is concerned. But unlike other natural law scholars that try to look at some metaphysical dimension, try to say that natural law is supposed to reflect certain abstract principles out there, he rather look at natural law from the point of view of procedure. So his natural law, so to speak, is called like procedural natural law. And what does Fuller means by that? That is to say that Fuller sought to explain the moral content in the idea of rule of law. So if we take like rule of law, for example, we take our constitution, the preamble, that we are establishing a government which is only founded upon rule of law. So governance by rules and judicial institutions, that is the sense of what rule of law. So if you take like this idea of rule of law, is there any morality in having an arrangement which says that people should be governed by rules, people should be governed by institutions? Is there any morality in those arrangements? Those are the things that Fuller was concerned. Because mind you, if you say yes, you have like the rule of law, you can actually have a rule of law which is seriously questionable. Remember your constitutional law, cases like the two Salifa cases, Espite Brahma, and so on, during the military rules. And you also remember the case of Ray Akuto, right? Ray Akuto, when the Supreme Court will actually find itself helpless, trying to say that, well, they could not constitutionally challenge the preventive detention order, which have been made by Nkrumah's government. So that really brings up the issue as to whether there is a morality in the idea of a rule of law. And that is what Fuller is telling us. So to Fuller, reason played a role in legal ordering, and it consists of discovering those principles of social order and will enable a man to attain a satisfactory life in common. In other words, the ends or purposes, which is the attainment of a satisfactory life, a flourishing life, that is how he put it in his work, require particular rules as a means. So Fuller takes the view that, yes, human beings, we are not just living aimless life. Our life is supposed to achieve a certain outcome. And that outcome is that our life should be successful, our life should flourish, we should realize our true self. So how do we do that? If that is the goal, then we need a means to attain that goal. And in Fuller's view, you cannot achieve those goals without also considering the means of achieving them. So when it comes to law, you make the point that law is the purposeful enterprise of subjecting human behavior to some control or some rule, so as to let human beings achieve satisfactory life. So applying this analysis or this reason to the process of legislation or lawmaking, Lon Fuller sought to show that the process of legislating was governed by objectively determinable laws, which were natural. So for him, if you look at how lawmaking is done, there are certain important principles which are objective. In other words, you can discern them using your thinking ability, and it does not depend upon anybody's subjective preferences. And these are